inclusive of discipline and write-ups in the Metcalf twin school records within this framework, as well as racisms. Every time I see that word, I just get sick to my stomach. In exchange, the prosecution would not go into character, reputation, and extraneous offenses, acts, evidence relating to Karmelo Anthony, inclusive of the contents of Karmelo Anthony's cell phone and school disciplinary records. What was in his cell phone? What was in the school disciplinary records that they were so scared? I'm talking about Mike Howard and Toby Shook, that they didn't want this to be in there. What did he say? What could he have said? What did he really do? We know he ain't have no real record. And we know when it comes to the twins' background and his background, they had more of a background, and more people were speaking out against the twins to say that they were bullying, they were aggressive. People didn't even want to fight Austin because he was big as heck, looking like damn Randy Couture, one of them guys in the UFC, even though he a kid. RIP to him still. I'm not going to kick it. You know what I mean? RIP to him. But this is what the kids, his own friends, people that was in his team, cheerleaders and all kind of people talking about him and them. So I got to play my sound. We working on a railroad today, y'all, in McKinney, Texas. Boy, all right, where the cell phone at? In his school disciplinary records. At this meeting, I sought clarification on how this agreement would work practically, specifically, and how to handle the possibility of opening the door to this evidence from either side. During this meeting, Mr. Worski repeatedly expressed his concern that the defense would kick open its own door by asking questions of witnesses that would delve into issues restricted by the agreement. I asked about specific statements made by witnesses interviewed by police and captured by video on the day of the incident, where those witnesses discussed the Metcalf twins as being passionate, triggered, and not tolerating being disrespected, etc. Mr. Worski eventually agreed that the questions narrowly tailored to ask about the specific statements the witnesses made to police about the incident under the tent on April the 2nd, 2025, including statements just described about the mindset and the action of the parties involved in the incident. In the incident would not constitute kicking open your own door, and thus would not violate our proposed agreement. During this meeting, we discussed the terms of the agreement, being that the testimony from eyewitnesses from under the memorial tent on April 2nd, 2025, and who were discussing the facts of what happened under memorial tent on April the 2nd, 2025, would be permissible, and that neither side would go into character, reputation, or extraneous evidence for either the Metcalf twins or Karmelo Anthony. And during this meeting, I also asked about the agreement regarding the possibility of defense calling experts. The prosecutors only discussed how the agreement would apply to defense experts during the sentencing phase. So I asked how the possibility of the defense calling experts to testify during the guilt innocence phase would impact the proposed agreement. The prosecutor team replied that they had not considered us calling experts to testify during the guilt and innocence phase. Oh boy, bro. Bruh. I'm not a lawyer, bro. I said Stevie Wonder can see this railroad coming right here, bro. My Sherry Amore. Stevie Wonder can see this railroad more and more. He can hear, bro. Stevie got sonic hearing, but he also can goddamn see this railroad, bro. They stated that if the defense called experts to testify regarding Mr. Anthony's epilepsy or about the fight or flight response, they considered expert testimony like that to violate the agreement and thus open the door to character, reputation, and extraneous offenses and acts of evidence. On May 11, 2026, Mr. Worski, Dewey Mitchell, and Mr. Shook and I discussed the proposed agreement again by phone. I informed the prosecution that we had an informal agreement on the proposed agreement, but that we needed to have a final conversation with Mr. Anthony and his parents to confirm the final agreement. During this phone conversation, Mr. Worski confirmed that the agreement would extend to the sentencing phase of the trial as well. Mr. Worski said that would mean that in accordance with the agreement, the prosecution would quickly rest its sentencing case in chief without going into any of the allegations listed in the state's notice. Mr. Worski said, however, that he would not allow a false impression to be presented to the jury by a defense witness. And if such thing happened and occurred, then he would respond by going into character, reputation, and extraneous evidence from the state's notice. After the defense asked about an Anthony family member testifying at the sentence, Mr. Worski agreed that the agreement would cover Mr. Anthony's mother testifying to the standard of this: "I love my son, please show mercy." That type testimony and no further. Stevie, you here? I'm here, Uda. I see the railroad, Uda. Sing me a tune, Steve. God damn. On May 21st, 2026, the defense and the prosecution team met with Judge Roach in the chambers. During that meeting, both sides explained the agreement to the judge, describing it again as both sides agreeing not to go into character, reputation, or extraneous evidence, as it applies to both sides during both the guilt and innocence and the sentencing phases. As long as no doors are open or false impressions given, we agreed that the best way to document such an agreement would be for the defense to draft a motion and file a motion in limine applying to character, reputation, and extraneous evidence applicable to all witnesses. So it would cover both the Metcalf twins and Mr. Anthony, but if made public, would not trigger reporting in the media about bad act evidence specific to certain witnesses, thus endangering a fair trial. On May 21st, 2026, I drafted the motion in limine as described above and sent it to Mr. Worski by email, and it was hand delivered to the judge on the opening day of trial. And limine means things that they do not want to be said in front of the jury. So if you say something in front of the jury, you then have opened the door, and now they're going to go into whatever they feel, which is character evidence, which is his cell phone, which is school disciplinary records, or whatever they want to go into Karmelo's background. This is what the defense is running from. Okay, kind of breaking it down for you. Okay. The defense's understanding of the agreement. The defense understood that the agreement with the prosecution to cover all witnesses who could be called to testify by either the prosecution or the defense about the incident that occurred between Mr. Anthony and the Metcalf twins and their teammates under the memorial tent on April 2nd, 2025. As every description, Mr. Worski described the agreement to allow for testimony about what happened under the tent, and Mr. Anthony was obviously a witness to what happened under the tent. So by the plain meaning of the language Mr. Worski repeatedly used, the defense always understood the agreement to cover Mr. Anthony's potential testimony, just as it would cover any other eyewitnesses to the incident under the tent on April 2nd, 2025. The plain meaning of Mr. Worski's words in describing the agreement, the defense understood the agreement to cover the testimony by eyewitnesses, such as the memorial